This is the Planning and Zoning Commission for the Village of Vernon Hills. We need to start with a roll call.
Chairman Morris,
Here.
Commissioner Blue, Commissioner Cotton, Commissioner Eisner,
Here.
Commissioner Heidner,
Here.
Commissioner Mulcron,
Present.
Commissioner Gorog. We have a quorum.
Okay. This is, sure there's a number with it. I just don't know what it is. Oh. Okay. Okay. Case number 1407, which is the petition by the village to amend Appendix C of the Code of Ordinances, to amend Article 4 to add a new section, 4.15, medical cannabis cultivation and dispensing centers. Okay, and this is a public hearing on that. So I guess first thing, notices to the extent necessary were published for
Correct.
this? Okay. You want to do I guess, an intro or
Sure.
Mike?
So on September 17, 2014, we held an informational meeting before the Planning and Zoning Commission to discuss medical marijuana as it relates to state legislation that was passed and called the Compassionate Use of Medical Cannabis Pilot Program Act. The act pertains to cultivation and dispensing of medical marijuana for use in serious diseases and causing chronic pain and debilitating conditions, this act became effective January 1st, 2014. Per the adopted act, cultivation centers and dispensing facilities are permitted to be located within any municipality subject to certain limitations. Municipalities may impose reasonable zoning regulations, but cannot prohibit these uses and cannot adopt regulations, the effect of which is to prohibit these uses. The village staff worked diligently over the summer to craft zoning language that would be amicable both to community stakeholders moving forward to address this act. A moratorium was passed last year that allowed the village the necessary time to understand the act, understand what regulations would be allowed, understand what conditions of approval may be granted, as well as just in general giving the time for the state to draft regulations pertaining to the act. During the informational hearing, which was televised, again, that is September 17th for those looking to view this online, the regulations and setback requirements were discussed as relates to both cultivation and dispensaries. At the time of the meeting, the commission reviewed some proposed language and asked questions as it relates to security and various setback requirements as it relates to dispensary facilities. As can be seen on the screen, the cultivation centers, per the state regulations for setback requirements from certain zone properties, extremely limits the ability for cultivation centers to move into Vernon Hills. The response, in general, the responses to the questions that you had during the first meeting were included in your packet. They were also included into the draft zoning language that is also included in your packet. Rather than going into each item in detail, that would be best to just open this up to any questions that you may have, at which time we can address each one in its corresponding fashion.
Jim?
Where are other municipalities in their development of an ordinance similar to this? Are we at the cutting edge, or?
We are not. We are probably late to the game. Many communities that we surveyed did pass moratoriums that restricted medical marijuana until such a time that they could propose uses. Some communities have opted not to take any approach because of the way cultivation centers and dispensaries are distributed throughout the state. Some communities would not be impacted by this legislation. However, others, depending on their interpretation of their existing zoning code, which does vary by community, some felt that there was already sufficient guidance within their existing zoning language to regulate medical sales or retail distribution of medical supplies. Mike, I don't know if there's anything to add for what you found.
No, I think that sums it up. I know
I don't know the exact number of applications the state has accepted, but I know they are beginning to accept applications, and there's a number of requirements that are a part of that application, and one of which is to demonstrate that you either have zoning compliance in the location you want to go, or you are acting or have an application in with that community to gain zoning compliance, and that's just one of many components that are required as part of the application to the state for dispensary or cultivation center. So that's what makes us kind of late to the game. I think if there's only 60 licenses that the state will issue, and these companies that are looking to locate, if they couldn't get good zoning confirmation to make a part of their application, then they just chose another location where they could get just that. And Vernon Hills isn't that for them right now because we don't have our zoning regulations in place. So the only answer we could give them is that, well, we have a moratorium, and we're going through the review process to pass regulations for it. So I would anticipate, at least initially, we're not going to see applications for a special use for a dispensary. And certainly not for a cultivation center, because there's just such a small area in the village that it could be located and still comply with state separation requirements, namely the 2,500 setback requirement from residential and other type of uses. So, but in any case, time moves forward, and if the state ever got to a point where they wanted to allow additional licenses, we certainly want to be prepared for that.
And does like Wisconsin have a similar law, or?
No, they do not.
So, under your definitions under card holder, you say that it has to be issued by the Illinois Department of Public Health, so that would prohibit any other non-resident of Illinois from purchasing?
That is correct. I believe that language was taken from the definitions that were within the state act. Yeah. Folks from California can't come here.
Anybody else? Is there anything that we need to put in the ordinance that says if one part of it is deemed illegal or inappropriate, that the other parts stay in effect? Is that within here?
Severability is in our general ordinance.
I believe typically it's in our general ordinance. When the special use is approved, there's always that language. To my knowledge, in my lengthy experience here, I've never seen an ordinance that didn't include that one as it relates to a special use. So that at the time the petitioner came forward, and as it relates to any existing or additional conditions of approval that may be granted as a part of a special use process, at that time, if an ordinance were to be granted for them approving a special use, that severability clause would cover the zoning language that's included here, as well as the existing or any additional.
Okay.
It's my non-legal JD term.
I think you're right. I think the ordinance itself, the zoning ordinance, has severability in it, probably too. Way back in the packet, and we talked about Article 16, BP Business Park Special Uses. Am I correct that, and maybe I'm not correct, that all the business parks that this could go in, and I guess it's the left map, would be in additionally subject to, they have their own covenants and restrictions on them? So is it going any place that wouldn't be covered by a covenant or restriction that a business park has?
For dispensaries, every location
For dispensaries, yeah.
would also be subject to Coventry's and whatever restrictions are on there. Now, in the case of Continental Executive Park and Corporate Woods, the annexation agreement for those properties has expired. The PUD will still exist in whatever those regulations are. So it was the advice of our village attorney that now that the annexation agreement is expired, they would have to follow the requirements of both the zoning code and the requirements of the PUD. So an amendment to the zoning code would be sufficient to trigger the requirements for a special use permit for dispensary and cultivation uses.
So you would need to also amend the PUD, because they're PUDs, aren't they? And those haven't expired yet, have they?
No, the PUDs do not have to be amended by the advice of our village attorney because they because the underlying the advice was the advice of the village attorney was they would have to follow both. So if we just put the regulations in one of those documents, in this case it's the zoning code, then that would trigger the requirements for a special use. There's nothing in the PUDs that would prohibit this type of use. There's really nothing either that specifically regulates it. So putting this in the zoning code would be enough, at least by the advice of our village attorney, would be enough to trigger the special use requirement.
So those PUDs allow retail sales other than by amendment to the PUD? I don't remember what we did with CDW and some others, whether we had to amend the PUD or not.
Well, it's medical sales, and so general retail sales, no. Medical and office supplies and those type of terms are indicated in the PUDs, and we believe that that's close enough to be considered a permitted use.
Okay.
That's our interpretation of the PUD.
But both business parks also have their own covenants and restrictions that are recorded against the land.
That's correct.
Okay. And it's clear to, I guess, everyone, without putting it in this ordinance, that although this is a special use that the village can grant, it does not in any respect supplant or change the requirement that you also need then the approval under those covenants that exist in the business parks.
That's correct. It couldn't, and it does not, and it's not intended to.
Okay. So there's no intention here that under our home rule authority that we're, putting some sort of overlay and making it something you can have if you can meet our special use. You still need to get their approval.
They still need to get their approval.
Okay.
We've had some developments, I'm sorry.
No, go ahead.
We've had some proposals for uses that were just very preliminary conversations sometimes within those areas where we will pull up the specific exhibit related to that annexation agreement for the zoning language restrictions. And that's one of the first things we discuss with them is that these covenants are still required to be met in order to
But aren't there
apply.
also separate covenants that the business parks have on?
There are.
Okay, right.
And one of the first steps in our process is approach the association,
Right.
and get their, if nothing else, their preliminary approval, so we can move forward with confidence that the association would ultimately approve it, which would mean you're in compliance with the covenants that apply to the property.
Okay.
The plan development, any plan development can amend their own covenants and restrictions that would say that they do not accept this use within their, or they restrict this use within their development. They can do that.
Yeah, that's correct.
So either it's I think what Mike is saying is it's an accepted special use by village ordinance in these areas and subject to acceptance by the specific plan developments that that these fall within. I think it's kind of like a two-step process.
It's actually probably three. It's our zoning, it's the PUD, and then it's the association's own covenants.
That's correct.
Right.
Actually, Chairman Morris asked me a question about covenants, and I answered a question about PUD
I
regulations. I just misunderstood the
Right,
question.
I understand.
But yeah, so there's the covenants, which is recorded against the property, regulated through the association. There's the PUD regulations which apply, and then the underlying BP Business Park zoning district.
But all the BP business parks that we're talking about here are subject to association covenants.
That's correct.
Okay. All right. Okay. And then you gave us different maps with different, I don't know how to describe it, either 500 or 1,000, et cetera. Right. The ordinance is written at 1,000. Are you suggesting we look at something else, or are you just showing it for illustration purposes?
The ordinance that we presented, or that we discussed at the meeting, was consistent with the state regulations are, which is that it can't be in a residential district.
Right.
So during discussions, it was like, well, what if we applied a separation requirement from a residential district, something more than what the state regulations are? And our response was we could put together some maps and have you take a look at them. And so we've done that. I think what I'll do is I'll work backwards. We started with if we were to have a requirement that would, which would say a dispensary could not be within 750 feet of a residential district, and we applied that regulation to see what the results would be, and it would impact 59% of the buildings that would otherwise be permitted if we didn't have a separation requirement. In discussing this with the village attorney and at staff level, we thought, this might be, and it's interpretive, and we might be crossing the line into something where our regulations are so restrictive, it's having the effect of almost prohibiting it. So this one seemed restrictive, but it's here for your review. Then we also applied a 500-foot setback regulation, and here's the impact of that. It doesn't show up as well on the map because the impact is subtle, but it would impact 42% of the buildings that otherwise be eligible for a special use. And you can see the buildings in here that would no longer be eligible by requiring a 500-foot setback. So that's there for your review. And then as we were discussing it at staff level, we came up with another idea. I'll put this over here. And the thought is, we want some level of separation from residential. We don't want a dispensary immediately adjacent to a residential zone property. So with that in mind, we came up with an adjacency restriction, whereby if the property is immediately adjacent to a residential district, well, it can't be. If there's a street in between the dispensary and a residential district, that would be considered not immediately adjacent. And so when we applied that regulation, you can see the properties that were impacted, and that would impact 14% of the dispensaries that would have otherwise been eligible for a special use. So this is the immediate adjacency, 14%. This is the 500-foot setback requirement, impacting 42%, and it's here for your discussion.
But those percentages are against existing buildings, is that correct?
That's correct.
So where it's just blue, is that buildable space?
The blue here?
Right.
Well, the blue...
No, I understand that, but if there's not a building there, it's either the lot around the building or it's buildable space?
Oh, I see, yeah. In some cases, it shows all the lots, okay, that would comply, and then some lots are developed, others are not.
Okay. So the percentage, if we, do we know what it is if we apply it to buildable or built lots?
It was applied to buildings, built lots.
But if we applied it to either buildable and built together, it's going to be a much slower percentage affected.
Well, we'd have to look and see if we had...
Well, those.
It would be lower, but it's hard for me to answer how much lower. I'm not sure how many vacant lots we have in the affected area, or if these are just, like this lot is probably combined with this overall large vacant lot.
Wouldn't you have to look at it
But
as
it's
all
logical to-
buildable? All the blue is buildable.
Right, yeah.
So it's
Just
all.
land area.
It's all land
Right.
area, right, potential,
Right.
whether it's developed or undeveloped.
So the impact is substantially less if you, even at the, was that 1,000 foot or 750? I can't see it.
This is the 500 foot.
Whatever it is, yeah.
Yeah.
Okay.
Did you also look at proximity to park? I noticed that VHAC wasn't taken into consideration with all the kids' playing fields right along the business park.
We did not. We did just the residential.
Okay.
So the language that's that's before you tonight is what you saw at the last meeting. It just simply that it can't be in a residential district. So if it's the Planning and Zoning Commission's desire to recommend a separation setback, we would need that directive so we can change the language before it goes before the board.
You want to go through that again? You want to say that again? There's not, it's prohibited in a residential district.
Yeah, right. The language that's before you tonight just says a dispensary cannot be in a residential zone district. If you wish to make that more restrictive and say, for example, require a 500-foot setback or require that it not be immediately adjacent to a residential district, then we would need that directive from you so that we could change the language before it goes to the board,
What was the?
which is actually pretty simple to do, just
That's from-
so we understand what
that's
you
from
want.
certain uses. That's the school uses.
Oh, the school use.
That's this
Yeah,
41552.
Okay.
yeah, 415.52, just for the sake of, if anyone watches the YouTube. It's there's setback requirements required by by the state act that said that medical dispensaries cannot be located within 1,000 feet of pre-existing public or private nurseries, schools, preschools, primary or secondary schools, daycare centers, or daycare homes. And so that's the language that's included in that document.
And if we want to add or suggest there be added a, some sort of proximity limit, that's in the section 2. That the dispensary should not be located in a home, apartment, condominium, or within any area zoned for or containing residential uses.
That's correct.
So we'd have to add it there.
That's where we would amend the language.
Okay. Thoughts, anybody?
I just had a philosophical legal question. Are we in violation of federal law by approving this, or if the village approves it?
Well, first and foremost, I do have to say that I'm not an attorney.
Okay.
So,
That's how I was going to start.
And he's
But-
happy about that.
maybe. So what we've spoken to our village attorney about this is that while federal regulations do classify the use of marijuana as some degree of felony, there's also been rulings and statements by both state and federal attorney generals who've stated that they are allowing states to allow the use of both medical marijuana as well as in the cases of other states such as Washington and Colorado for recreational use. Now, that being said, there are certain issues that will arise, for instance, an employer who accepts federal funds who also allows individuals to utilize medical marijuana. There's questions on a HR personnel issue of how that will be handled, how the federal government will manage that process. At the same time, the village does, in the opinion of our council, need to take an appropriate step to respond to state legislation that has been passed that has granted medical marijuana as an approved and licensed use through the state. And so utilizing that interpretation, I believe that is where the Planning and Zoning Commission is able to legally have a recommendation to the board on how best to regulate that use within the community.
Okay. So under state standards, it's legal. Federal, it's still illegal,
Correct.
generally. Okay.
What the, at the expense of sounding, like I disagree, I guess I do. I don't think that's really what the law is. What the law is right now is that it's a controlled substance under the Federal Controlled Substances Act. And the Attorney General's office, the U.S. Attorney General, through a memo that was sent about 1.5 years ago, said that the Attorney General in states where it is legal has chosen not to exercise prosecutorial discretion and prosecute for violations, so long as it does not implicate other important federal policies. It's still illegal. It's not that it's not illegal. The state has simply said that it's not going to prosecute under any state law. Okay, but it's illegal under federal law. There's not any question about that. And, with the upcoming election, who knows what'll happen? You know, if there's a change in Washington with the new Attorney General, it's not Eric Holder anymore. You know, the other difficulty is that because of that, federally chartered and federally insured banks cannot take the money. Because to take the money from these would require taking money from a criminal activity, which then triggers a whole set of reporting regulations, and most federal banks won't take it. Similarly, although it's licensed on the state level, most large or so-called mainstream insurance companies will also not insure. So you can't go to Allstate, you can't go to State Farm, you can't go to Travelers, they won't insure. You go to these odd different, it's like Canna Insure, things like that, which are risk pools. So as a result of that, and that's why I asked these questions before with the police department, which I think maybe they didn't quite grasp, that these become difficult issues because they're fully cash businesses. Because of the question, are you violating federal law? Yeah. Are you violating state law? No. Is it part of zoning? Yeah, you can zone for it, if you want to, or zone against it, if you want to.
Okay.
And even the state act is a pilot act. It's not even a so-called permanent act, necessarily.
Okay.
What he said.
I mean, and I'll tell you that, if you're in a regulated profession, there's questions being in a regulated profession, what you can do with it. Like I said last time, that's why I won't vote on this. There's a serious question as to whether, an attorney can vote other than saying this is what state law is, because it's effectively indicating how to, quote unquote, break a federal law. And I do not know under your architect's license whether it has the same implication or not.
Probably.
Though I will tell you that there are in other states, there's decisions that if you're a licensed attorney, whether you can even use it for medical purposes, or you're running afoul because you're using something that's violating federal law, and therefore it puts your license in jeopardy.
Okay. Thank you.
Yeah.
There's a lot of attorneys in California who disagree with that.
There are. I mean, the other thing I'll tell you that comes up a lot is Colorado has a very serious problem, is that it's legal to buy for recreational purposes. People buy for recreation. They put it in their car and they drive across the state line. They get arrested in Nebraska. They also get arrested quite often by TSA at Denver International Airport. You can't bring it on an airplane. So there's a whole series of problems with it. Okay. With that odd little discussion, do we have any comments with respect to the this buffer zone or this proximity issue? How we want to phrase it?
The options we're looking at are 750, 500, and adjacent residential.
That's correct.
Or leave it as it is.
Or leave it as it is, which means just not in a residential zone district. And the effect of that is the blue.
Will one of these maps then be part of the ordinance?
No, they simply represent, there won't be an overlay district, but they represent what the result is by applying a buffer zone or not applying it. They're just there to be representative for you.
The maps would be there, it'd be a guide.
Right, and for whoever's
Whoever's
issuing the
considering,
permit.
or who's ever considering.
Yeah, I mean, we could, if you decided to do a buffer, we could use it as a tool when people are coming in and asking questions. But it wouldn't be an overlay district, wouldn't be a part of the zoning map.
On the operational side of things, very likely what we would do is we would incorporate this into our GIS function, so that should a developer call saying, hey, I'm looking at this property for dispensary, we could pull it up and say, well, per our zoning restrictions, that's not permitted at that location, or that is permitted. And that'd be something that we could share, but it's not specifically an overlay district as was stated.
If the village did a buffer around residential at any, I don't care what number it is, at any amount of feet, and someone came in with a property that fell within that buffer, we could tell them that. Wouldn't they have the option of going to ZBA to seek a variance from that?
Well, they would still need, the answer is yes, but I'm thinking aloud as I answer your question as well. I mean, typically, an application that requires a special use permit and has associated variations, we typically send just to the Planning and Zoning Commission. So the answer, even if they got the variation
Sure.
approved by ZBA, they still need to go through you guys.
Fair, okay, fair enough. Okay.
Show any preference?
Jeff?
I like the more restrictive one.
750?
Yeah, because I don't buy into the adjacency restriction when it's, and just speaking from my own neighborhood, just because it's a street, those buildings I can see from my house, and so that seems really close. And there's people that cut through because they actually live in my neighborhood and work in those buildings, and there's I think 3 cut-through paths that have been naturally created, so people cross that road all the time, going to work. So, and then
Because there's a roadway there, fair,
Yeah,
it's Fairway.
uh,
Yeah.
yeah.
Yeah,
And then the adjacency to the high school and all the athletic fields too. People park in those parking lots along those buildings to use those athletic fields for their kids. So,
So you're looking at the 750 one, which was that one? No.
It's not showing.
It's got-
This is the 500
That's fine,
foot.
right,
That
that,
one's
that's 750.
Started feeling a little uneasy with it because out of the entire village, we're down to certain little areas for dispensary. It's subjective to, determine if you think it still meets the intent of the pilot act.
I would just note that regardless of what's decided in terms of adjacent or buffer, I mean, this all still would be required to go to special use, and that does not guarantee approval. And I do think the board would take into strong consideration exactly the points you've made, and I think the commission here would as well. And I think even at the concept review process, that's a conversation we'll be having with them is, it maybe just because it's, you can come before and apply for special use doesn't necessarily mean that you're going to get it, because you've got, all the different things like the VHAC that attracts minors in recreational activities that would not be in keeping with a business area, which is by and large what that area is.
okay.
Because of all the checks and balances that this would have to come through, all the different groups, this would have to go in front of any kind of petition that would come forward. It's my opinion that either we leave it as it is, written here, or we work with the just adjacent map. I think that offers the most flexibility to make a decision as a petition is brought forward to either Zoning Board of Appeals, Planning and Zoning, or the Village Board. I think flexibility at this point in time is probably a good thing, because as this issue evolves over time, things are going to change, and I think if we leave it as we have it, either in this document in front of us, or we keep it minimally affected by the adjacency map, then I still think that there's a lot of checks and balances in place to make specific and good decisions at the time of the petition. So that's the way I'm viewing this.
Jim?
So you want to go further than what, as written, you want to go to the residence adjacency?
The right one?
Either the one on the right, or as it is explained in this document, which doesn't even take into account adjacency. It's the blue area.
Mm-hmm.
There it is.
This map shows as written before you.
seconds left, but okay. Okay. Any other comments or questions on this? Okay. Although it's not a large crowd this evening, because this is a public hearing, we can open it up for public comment. And seeing no rush to the podium, we can close the public comment, on it. So what we're looking for this evening is a recommendation with respect to the draft ordinance for cultivation and dispensaries, as well as the two changes to the B1 and the BP Business Park in terms of adding additional special uses. Is that right? So how do you want this voted on in the most effective way?
I believe it can be voted on as a single item if that there's a general feeling that the only item that is up potentially for discussion is the setback requirements for dispensaries.
So what if we vote on, if we can figure out which one to vote on? We can vote on, I guess, each of the setbacks, and then vote on the ordinance subject to whatever the setback vote is. Is that the best way to do it? Sure. Does that make sense?
Would that give that would give the clearest opinion
right.
of this commission moving forward?
Does that make sense? Any other discussion?
So you're going to go through, leave it as is, residential 500,
So
750.
there'd be no setback adjacent to residential, setback requirement,
Adjacency setback,
500, and then 750.
correct. Yeah,
That'll
no-
give the
No
clearest-
setback, adjacency, 500, 750.
Okay. And then whatever that is, it would be, we could then vote on the ordinance subject to whatever those votes are. Does that make
Sounds
sense?
good. Yeah, that sounds
Okay,
good
so any
point.
comments first? Okay, then we,
I have
Okay,
one question, just a clarification for my benefit. On section 41555, where it talks about limiting access, I'm not sure I understand what the word access means entirely. It says access shall be limited exclusively to dispensary staff, card holders, designated caregivers, local and state officials, and those authorized under the Compassionate Use Act. Who,
We were asked to clarify, to add definitions for staff, cardholder, and caregiver to help clarify that. And really what it comes down to is,
but I guess I'm questioning what access means. Does that mean you can't be on that, in that facility at all?
correct.
So these people have to hire their staff elsewhere?
No, they just have to be older than 18 years old.
No, that's a separate statement.
It's all the same.
Hire, well, if you're a staff person, you can be on there, then you meet.
But if
the-
you're,
I see what
you're,
you're saying.
you're trying to get a job there,
Yes,
you would have to interview somewhere else. You could not come to the site because you're not one of those classifications.
That's for the cultivation center,
yeah,
No, it's
not
under-
dispensary.
It's under both.
yeah, we got it under both.
it's under
And
both.
Yeah,
Yeah.
I mean, yeah, the net effect of the way this is written is you'd need to interview the potential employee at an off-site location.
Okay.
Because
Yeah, they-
technically, you're not yet a staff person.
okay, any other comments or questions? Okay, then I guess for purposes of our first motion, it would be motion to recommend approval of, I guess it's an ordinance with regard to medical cannabis dispensing facilities with no setback from residentially zoned, residential zoning, I guess is what it would be? Is that right?
Yeah, that's what residential zone districts.
Residential zone districts. So we need a second for that.
I'll second that.
Okay, any discussion on that one? Okay, so we're gonna vote on, this is no setback at all. So it's as,
Can I
it's,
ask a question?
Of course.
Are we only allowed to vote positive on one of the options or multiple?
You can vote on multiple.
multiple,
Okay,
whatever you want.
all right.
So that's the map that's on the bottom left. Right? Do I have the right one?
Would this
Yes.
be
Right here.
considered an official motion, or is this more of a poll? Am I taking roll?
The motion was to approve the amendment in accordance with this map.
I mean,
So we do
Because
either
what
way.
happens if we approve more than one?
You know, that's a good,
That is a good
that's a
point.
good point.
So why don't we do it as a poll first, and then we can go back and do it as a motion if we need to? Maybe that's the way to do it?
So we table the motion, I guess, then?
Yeah. I don't know.
Just,
Okay, whoever's, okay. Okay, so we need effectively a poll on that? How do you want to do it?
Yeah, yeah, let's do that.
Okay. Okay, so that's the no setback. We'll start at the left.
Yes.
I abstain.
Yes,
so 2-2,
Okay,
2-1-1.
2-1-1. Okay, what about with adjacency to residential? We can start on the right this time.
yes,
I abstain.
Yes.
No.
Okay. 500 foot to residentially zoned districts,
Yes.
Yes. Yes.
no,
and I abstain. Okay, and 750?
no.
No.
Yes.
Okay.
So this is fun.
So where are we?
I guess there are several different options. I mean, you know, right now, I mean, I think, and correct me if I'm wrong, so the last meeting on this, in September, we looked at different setbacks that were asked. Really, the board, or the commission, excuse me, if, you know, you can either, I think, as a whole, either if you have additional questions, or you want to have additional meeting on this item, or would you prefer to have a vote on the item and just let the vote and the stand where it may? And that's,
Well,
from what I'm hearing, would be a 2-2 vote, which would then be,
2-1.
well, yeah.
I guess,
2-1-1.
2-1-1.
I guess if the polling considerations could be included in the minutes, which they should, then I don't see why we couldn't just vote on this.
As written with no setback?
Yes,
suggesting?
as it's presented.
Okay, we can do that.
Because then at least the
They know what we
disposition,
thought.
yeah,
Just so that comes out in the meeting that they have.
yeah.
Okay.
As long as somebody knows, as long as the board knows what we were thinking of.
Okay. That makes sense. Okay, so then what we'd have is a standing motion to approve the amendments to Article 4 to add Section 4.15 medical cannabis cultivation and dispensing centers, as well as amendments to Article 13 B1 General Business District and Article 16 BP Business Park District as presented. And that includes no setback from residentially zoned districts. So we need a second for that.
Second, I already seconded.
Oh, you already did? Oh, I'm sorry.
I think,
No, yeah, I counted that.
Okay, okay. Any discussion? Okay, I guess we can vote. This is a roll call one.
All right. Commissioner Baloo? Commissioner Cotton? Commissioner Hesner?
yes,
Commissioner Heidner?
Yes.
Commissioner Mulcrone?
No.
Commissioner Garag? Chairman Morris?
Abstain. So it's 2-1-1.
Yep.
And then the other comments with regard to the polls on the other so-called adjacency or setbacks. Yep. Okay,
So the 2-1-1 vote, is it down, right?
pardon me?
Is that approved? or-
It's approved.
Oh, it's approved.
Yeah.
Well, we will definitely include the minutes and include the comments. What we'll have our staff do is we'll make sure that it's very detailed minutes to make sure that everyone understands what was being discussed and how it was discussed. And then this will appear at the committee of the whole meeting, either on the 5th or on the 18th. Just honestly, just depending on how
Will you
full
be
the agenda is. I'm sorry?
Will you be presenting?
Yeah, I'll present before the committee of the whole, or Mike and I will do it together. We'll see how nice it feels.
I don't mind if you try to explain it, Joe. That would be just fine.
Okay.
I mean, for purposes
I'll
of...
be there to help you, and we'll try to make
Sure.
it clear, because the way the voting went was, it was obvious how the voting went, and we'll try to make that as clear as possible, not only in the minutes, but in the way we presented at
Sure.
the committee of the whole.
And for
Yeah.
purposes of explanation, although I didn't vote, had I voted, I would have voted for a more restrictive setback.
And I think the point about park and the VHAC, I think will definitely be noted in the minutes
Yeah.
to ensure that that is a concern that is brought up to their attention.
Okay.
So we'll make sure we.
Right. Okay, do we have anything else we need to know about before we approve the minutes of September 17th?
Nothing under development review. However, as a matter of discussion, at the committee of the whole meeting last night, the College of Lake County appeared with a proposal for an addition for a one-story chemistry lab. They're seeking, due to the zoning changes that were made in 2012, it requires a special use permit for educational facilities within the public and institutional buildings section. They will be seeking variations for a landscape buffer setback as well as a side yard setback. While the building is aligned with the proposed buildings and in line with the existing buildings, because the revised changes, it is in violation. In addition to that, there's some discussion, there is a chimney for a chem lab for exhaust and those items. Per the act, it does need to be screened with the identical masonry materials as the building is. That's an item that they have talked to me, at least today, about feeling that that will actually be more of a eye catcher than just having it as it's being proposed. We haven't received any technical comments yet, so we haven't started that process yet, but that is going to be something that moves forward. The other item is the Oaks. They also appeared before the committee of the whole. They're looking to expand their apartment building to the triangular property that is along 45. That's currently zoned B1, so that'll require rezoning as well as an amendment to the PUD, as well as the associated variations that were granted for the Oaks. They're seeking for this particular property. It'll be a 3-story, 30-unit apartment structure, identical architectural as the rest of the single-family or rest of the apartment buildings in the Oaks. It's really just simply expanding it further. Due to the occupancy rates that they've been receiving, they're looking just to continue progressing, and they feel that this will be a better use than a commercial, and this will be a better site for that.
Have residents moved in some of those units?
Yes, they're in the northwest building is already complete, and they already do have occupancy. So apparently they're getting a solid foot traffic coming through. They think once construction, they're doing final paving over there shortly, and they think once that happens, they're going to get even more traffic as people kind of see it more as a developed site as opposed to an ongoing construction site. So that's coming up. And then another item that's coming up is, I'm not sure where the village had several committee of the whole meetings to discuss a parking study that was conducted along Deer Path. There was a discussion by a trustee some time ago of whether to allow parking on the roadway along south of Sullivan on Deer Path due to the restrictive ability for residents to park on their driveways, as well as restrictions that are placed on residents to not park on sidewalks. And so there was discussion that was involved here. Several conversations took place. Ultimately, the board is directed the Planning and Zoning Commission to review a proposed ordinance that would expand certain driveways to expand their width if the length of the driveway is a certain maximum. So essentially, if it's a small driveway, they'll be permitted to have a wider. I'm butchering the explanation, but
Yeah, that's all right. There's certain this is an area that is south of Sullivan. It's on Deer Path, south of Sullivan, north of Route 45. There's certain properties that have a short driveway. Those are the raised ranch type designs mostly, and it would apply to just those. Deer Path is unique in that there's no on-street parking at any time allowed. So they have issues with guest parking, college children coming home for the summer, and those kind of issues. So the amendment would, for just those properties with the shorter length driveway in that area, would be allowed a wider driveway, in effect a 3-car wide driveway, so they can get all their cars to fit on the parking lot. There's other homes, if you go down Deer Path, you'll see they're L-shaped, and those driveways are much longer they would not benefit from that exception in the zoning code.
So what, the driveway will go in front of the house? Is that what'll happen?
Yeah, there would be, yeah. They would widen, they could, if they widen towards the side property line, they can do so to a point where they're still maintaining a 5-foot setback. And then if they needed to get any wider, they'd have to be able to do so into the front yard. Right now, the zoning code allows a driveway width that is no wider than the garage, which are 2-car garages in that area. So, so the driveway will could potentially look 9 feet wider than the garage. Just so you can picture what that would
So
look.
does that change the apron and the curb cut then too?
It only applies to the driveway on the private property. The requirements for the apron would remain the same, which is maximum 24 feet at the curb, 20 feet at the public sidewalk. That would remain unchanged.
Okay.
We will have maps available and aerials to kind of show what this would look like, and kind of give you a visual presentation of this. That-
They have enough room to taper it so that it can maintain that width at the street?
Yeah, it'll, and we'll provide some exhibits for you, but, you know, it's almost the reverse of the way an apron is. You know, an apron, the driveway approach is wider at the curb and it narrows when you get to the public sidewalk. And then when you get to a wider driveway, and there's examples of this actually in Greg's Landing, the width of the private driveway would equal the width of the approach at the public sidewalk and then widen out as you get into the, you know, closer to the house. So, I mean, but we'll give you some examples to look at.
Those items.
Okay. All right.
I'd likely have a public hearing. I know Lisa sent out polling information. I think the thought was to potentially do this end of November, early December, obviously consistent with availability. I know it's with the holidays coming up, it can become more difficult, so.
Right. Okay, then we have approval of the minutes from September 17th, 2014. We need a second on that.
I'll second.
Any discussion? We can do it by acclamation. All in favor?
Aye.
Anyone opposed? Okay, that passes. And if we have nothing else, we have a motion to adjourn. We need a second.
Second.
Can we do that by acclamation? All in favor?
Aye.
Aye.
Anyone opposed? Okay, we're adjourned. Good night.